Good morning, everyone. This is Stephen Long, also known as the Notorious BIC, coming to you from my computer to share with you a brand new form just released this week. It is an overhaul of the exclusive buyer agency agreement. So, real quick, I wanted to take you through the overview of this. Not much has changed as far as content, but the format is drastically different, with the form only being a total of 3 pages. So starting at the top, you'll see that it is still labeled the exclusive buyer agency agreement, and the first line will be between the buyer and the firm. On the first section, the buyer will assist in finding the following real estate property type and location. This is where you would normally put in the original buyer agreement the address, the town, city, location. It could be a number of different things here to properly identify the property for which you'll be helping that buyer find. Could be geographically located, could be a one-off address, it could be a city, town, but it should, and it could also be for, land, single family homes, whatever you want to put in there to best describe what you're helping that buyer procure. And then it goes on to, for section 2, talk about the buyer disclosures. This is a nice new form that, or change in the form that makes asking these questions very succinct. First of all, has the buyer signed a document with another real estate agent or firm? I really like that because it says signed a document with, which means oftentimes consumers don't know what they have signed. So have you signed any documents with another real estate agent? If so, then the buyer agrees to share that information with you and your firm so that you can contact the firm for which you signed something to make sure that you can actually provide services to that buyer without being in conflict of an existing agreement. Under Section B, the buyer is or is not working with a reload company. That could be very important because they typically want a referral fee. So I want to make sure we are prepared for that. C, buyer has or has not received sample copies of the offer to purchase and contract, as well as purchase professional services agreement. I encourage you guys to give those samples out to them at least, if not before the time of offer. It's very helpful, especially from the professional services disclosure form, to have a checklist of things that they may want to be considering of doing an inspection at the time they're looking at property. Paragraph 3 says term of the agreement. This is when it will end. It will start today as the effective date, which is when both parties sign, and then it will end on this date or closing, whichever occurs first. Under paragraph 4, we talk about getting paid. This is great. So I really like how this is broken down now with the first, and you can check all that apply. It doesn't have to be just one. So you can charge a non-refundable retainer fee of X, which will be credited towards the firm's commission at closing. So if you were going to get a $5,000 commission and offer a $500 retainer fee, then they would owe you a balance of $4,500 at the closing table. There is a percentage of the gross sales price, which is not dissimilar from what we're used to. It could be a flat fee. So if you have a flat fee service for helping your buyer do maybe a particular task, or if the buyer and seller have already come together and just need a broker to help them, and maybe you want to reduce your fees and not have it because you wouldn't have as much marketing costs, you could put in a flat fee amount there. Or perhaps it's just a low price property, like a small piece of land or lot, and you could put a flat fee there as well. If none of those work, then just put in the other specific amount right there on that line. Just do remember that your compensation has to be specific. It cannot be a range. It cannot be per MLS because we don't put it in MLS anymore. So it just has to be very clear and specific what your fees for your services are going to be right there in paragraph 4. It does go on to say that if the buyer, the fee will be due if the buyer does close. Also, I highlighted this line because it does say, and it's important to let the buyer know in the event the buyer, if this contract closes or defaults on that contract. So there could be a fee earned there if the buyer breaches. Paragraph B, I highlighted a section there that says that the firm will first seek that compensation from the seller, but also highlight it and share this with your buyers, that the buyer understands that neither the seller or the listing firm has an obligation to pay your fee, but we will first seek it from there. So, Mr. Buyer, if the listing firm or the seller is not willing to pay me the above fee, that leaves you responsible for covering that or covering the difference in what they're offering versus what we've agreed to today. Under paragraph C, it talks about mutual termination required, meaning this is in effect until the expiration or closing unless both parties execute a termination of agency agreement. Section D goes over the protection period that says within X number of days of this agreement, if a property I showed you is the property that you purchased without having entered into an agreement with another agent, then I would still be owed our fee as dictated in Section 4 at the top. Paragraph 5 does remind them that there is no fixed standard or established firm fees, or they are fully negotiable. It does highlight in this section, or I did, the firm cannot be paid any additional compensation unless this agreement is amended. So in the event you have your fee addressed in this buyer agency agreement, as you should above, if you should be getting anything different than that, you would have to come back and amend it, or your firm would not be allowed to receive that compensation. And note, it also states that the buyer has no obligation to agree to that additional compensation. Paragraph 6 goes into detail about the idiosyncrasies and pros and cons of dual agency, and it will go through, and I encourage you to read these. I'm not going to school you on the difference between designated and dual agency in this capacity, but if you are going over this with a buyer, you need to read through and make sure they understand the terms of dual agency. It does say at the last one that the buyer has determined that the advantage of dual agency outweighs the disadvantages. And if they are going further, they would check one of these boxes saying that, yes, I am acting, giving authorization for the firm to act as a dual agent in that transaction. Now, it does vary. Now, if they don't want that, so if they're not into dual agent, do not let them initial this, because if not, the buyer will have, and it goes on to say, exclusive representation under this agreement. Now, the next section here, if they have checked that they are okay with dual agency, this is where they're going to determine, I am okay with you representing both the buyer and the seller in a dual agency, meaning one agent as the dual agent, or I prefer to have designated dual agency, which will be two different agents from the firm representing, one representing the buyer, one representing the seller. So they would have to initial one of those. And so you would have them initial here saying, I'm okay with dual agency. And then one of these saying either I'm okay with you being both, or I prefer it to be two agents. C just goes over that the obligations of an agent to discover and disclose material facts to all parties. D is a waiver of liability for anything other than violations of license law or intentional wrongdoing. Number 7 is a reminder that video surveillance is allowed legally, that audio is not. However, that may not always be the case. And to remind buyers that they can't take inappropriate photos or use them for any reasons. For example, if they're taking pictures of medicine cabinets or things that are in drawers, that would be a violation of proper photography or proper use of photography by the buyer. And most importantly, this is one thing I've highlighted because this has come up, the firm may or may not have control over the pictures or videos of a property that the buyer may purchase. So sometimes we've had buyers purchase a property and then want all the pictures of that house off the internet. That can be a problem given that it goes to a lot of websites that we are not in control of, especially as the buyer's agent, seeing how as a listing firm would have been the one to put those up. So just a little disclaimer there that, hey, Mr. Buyer, you're going to buy this house, but pictures of it may still be on the internet around and about. So just so you know, fully disclosed there. Under Section 8, Paragraph 8, it goes over that we are brokers, not any other type of professionals. Buyers should seek legal advice regarding law matters, taxes, financing, surveying, wood destroying insects, etc. One thing I did highlight here is the buyer agrees to fully indemnify the firm if a claim is brought against the firm stemming from the buyer's use of other professionals or buyer's election not to use other professionals. In short, that's saying that if I recommend my home inspector and they do a terrible job, you're indemnifying me for recommending them. So that's helpful, as I know agents are often hesitant or gun shy to make recommendations. You can do so. I still like to disclaimer that the buyer should shop and find who they want, but that is an indemnity to hold you harmless. Under paragraph 9, inspection costs, this is just a reminder to the buyer that whether they close or not, they will be responsible for paying the cost of their inspections. The rest is pretty standard canned language from the previous contracts. confidentiality of offers. The buyer and the listing agent are bound to keep those confidential. Sellers may or may not, as they are not under our control under license law. And wire fraud addendum is still very important under paragraph 11, so make sure you explain that. If you have any other additional terms or conditions that you want to make a part of this agreement, you can insert that in paragraph 12. You can even write in C attached if you have something specific that is lengthy in nature. Under paragraph 13, just goes over merger modification, assignment, enforcement, basically that this is the only agreement, any multiple copies of this agreement, excuse me, constitute this agreement. And it does state that if in the event there are legal proceedings, that the prevailing party shall reimburse the non-prevailing party for reasonable attorney's fees and court costs. The paragraph 14 is your non-discriminatory bold capital letters language, non-discriminatory language that is a part of our agreements as required by law. And then you would have everyone sign and date. Keep in mind that does have the buyer's date, signature, and contact information. Also, as the agent, make sure you're putting your firm number. And I like how they had your firm and license number lined out very specifically here, as the Real Estate Commission does want to see those on your buyer agency agreements if you ever have to provide one. And that, my friends, is the end of a 3-page buyer agency agreement that is very short, sweet, and to the point. If you'd like to hear John Waite, who is the legal counsel who helped write this form, as well as a couple of others, I will share the link to his 37-minute video going over it, but I thought I'd make a quick snippet for here for you guys, just so you can have a quick overhaul of this brand new form that will replace the original exclusive buyer agency agreement with this nice three-page concise form. If you have questions, let me know. Otherwise, enjoy and happy selling.